Commonwealth v. James A. Witkowski.
Good morning.
You may begin.
Thank you. Attorney Theodore Riordan on behalf of the defendant, James Witkowski. This case presents several issues, starting with the jury's question about what inferences it can make from the lack of evidence. The due process clause in the presumption of innocence requires more. It requires an additional instruction that they may not draw any inferences from the defendant's not putting on witnesses or other evidence. The judge's instruction also violated this court's missing witness law, which requires judicial pre-approval before a negative inference can be made against a party for not calling a witness. Now, we don't know what inferences the jury had in mind, but we do know that before this, the question, the jury was at 6-6, and that the jury, after this, came back with a unanimous verdict. This was a very close case that ran into 4 days of deliberations. Thus, there is a substantial risk of miscarriage of justice for the failure to properly fully instruct. The jury was instructed 2 days earlier in the jury charge on one occasion about no inferences about the defendant not testifying, and on one occasion about the defendant not having any burden to produce any evidence. But that was 2 days earlier. And in light of the fact that the jury is now coming back and asking about what inferences that we can make from the lack of evidence, it makes the acuteness, the need to re-instruct on exactly this issue all the more important. Going to the next issue, the improper closing argument by the DA. And this has 2 aspects. The last argument is the defendant's request for a modified Tui Rodriguez instruction.
I get what you're saying is we need to update our Tui Rodriguez to make it conform to our beyond a reasonable doubt jurisprudence, correct?
Right.
I appreciate flagging that issue.
Thank you.